All right, well, welcome back, and we have another panel for you now, which I know is once again going to be one that offers us a rich and fascinating discussion. We're taking you through a journey of obviously the many different dimensions and aspects and faces of all the issues that arise around national security and human rights. We began with people speaking about how lives are turned upside down and torn apart by the human rights violations that occur in the context of national security. We heard a fascinating exchange about the ethical dilemmas and the practical challenges of reporting in this context. We've obviously heard a fascinating exchange about what it is to judge, what it is to inquire, and to try to get to the bottom of what has happened. And now we're going to hear from four individuals who are, by any measure, amongst this country's most dogged and determined and experienced lawyers when it comes to doing the advocacy with respect to upholding human rights in the face of national security. Four lawyers who have done, are doing, and I know will continue to do that work in a whole variety of different legal settings as well. And I know it's going to be a fascinating exchange. We have Paul Cavalluzzo. Paul is a leading constitutional, labor, and administrative law lawyer. He has argued significant cases before the Supreme Court of Canada, the courts of Ontario, and labor and administrative tribunals. He's been involved extensively in public law litigation, and he was appointed to act as lead commission counsel to the Arar inquiry. We heard from Justice O'Connor as to what a valuable role he played, and also as lead commission counsel in the Walkerton inquiry. He has argued several cases before the Supreme Court of Canada concerning the rights of farm workers to collective bargaining, the liability of Crown attorneys prosecuting criminal cases, the rights of public servants to pension surpluses, the rights of workers to strike, and the reasonableness of a security certificate. And rightly has been acknowledged and commended for his work. He has the Law Society Medal, the Cesar Chavez Black Eagle Award, the Order of Ontario, and the Order of Canada. Paul will be followed by Marlys Edwardh, who is a senior partner at Sack Goldblatt Mitchell, which she joined in 2011. She is a graduate of Osgoode Law School and has a master's degree in law from Bolt Hall, University of California at Berkeley. She has practiced in the fields of criminal, constitutional, administrative, and national security law. She's taught at Osgoode Hall and the University of Toronto, and she has served as commission counsel in a number of royal commissions of inquiry, including the Blood Inquiry and the Commission of Inquiry into the Facts of Allegations of Conflict of Interest concerning, God, you love the names of some of these inquiries, concerning the Honourable Sinclair Stevens. Some of us will remember that one. She's been counsel to Donald Marshall, Jr. at the Marshall Inquiry, and counsel to Maher Arar at the Commission of Inquiry into his case. She too, rightly, has been commended and honored for her work. She has honorary doctorates from the Law Society of Upper Canada and from Osgoode Hall Law School, and has received a number of distinctions, including the J. Arthur Martin Criminal Justice Award, the Women's Law Association's President's Award, the Diane Martin Medal for Social Justice, the Award of Distinction from the Toronto Lawyers Association, and on it goes. And she is a member of the Order of Canada as well. Marlys will be followed by Barbara Jackman, who was called to the bar in Ontario in 1978, and since that time has very much focused, and many of us know her for this work, in the areas of immigration and refugee law and related constitutional litigation in the areas of immigration and refugee law. There's very few lawyers who have done as much to advance constitutional protections for immigrants and refugees. She has taught at several Ontario law schools and is also a very active contributor to continuing legal education programs in a number of areas, including immigration and refugee law, racial profiling, the role and practice of the Federal Court and the Supreme Court of Canada, issues related to immigration and national security, domestic and international human rights norms and practices, and advocacy before international human rights tribunals. She has been involved in many organizations, the immigration section of the Canadian Bar Association, the Canadian Civil Liberties Association, the Defence for Children International, just to name a few. and has been honored, including with the Vince Kelly Award from the Centre for Refugee Studies, the Award of Justice from the Ontario Advocate Society, the Law Society Medal, and honorary doctorates from the Law Society of Upper Canada and the University of Windsor Law School. And then finally, we will hear from Phil Tunley. Before joining, Phil practices with Stockwood's litigation firm in Toronto. Before joining Stockwood's, he had 17 years of experience in commercial litigation at 2 major Toronto law firms, and has a public law practice very much grounded, amongst other things, in his 4 years as counsel with the Ministry of the Attorney General of Ontario. He has specialized in constitutional litigation and regulatory prosecutions, with special expertise in disputes involving Aboriginal peoples and their rights, crown liability, white-collar crime, and a variety of other regulatory, administrative, and constitutional litigation. He's appeared before all levels of court in Ontario, the federal courts, and the Supreme Court of Canada. He serves as a director of the Canadian Journalists for Free Expression. Amongst the many important cases that he has been involved in, he has been extensively involved as part of a legal team, but a central member of the legal team, representing the 3 individuals who were the subject of the inquiry led by Justice Iacobucci. And that has involved proceedings in the Ontario courts, the Federal Court of Appeal, seeking leave to the Supreme Court of Canada. I think we're going to hear more about it, but it has not been dull, to say the least. So you obviously have an incredibly experienced and expert group of lawyers to hear from, and I will turn it over to them now, beginning with Paul Cavalluzzo.
Thank you very much. Thank you very much, Alex. Can you hear me at the back? Okay. I want to, at the beginning, thank Alex for certainly organizing this wonderful conference. Where else could we see 3 judges talking about public inquiries, and indeed 1 judge afterwards giving a press conference? So it is a magnificent conference. I'm going to be talking about in-camera or secret hearings, and I do have a lot of experience with that because as Justice O'Connor said, I was the Commission Counsel to the Arar inquiry and also act as a special advocate in security certificate cases. And I want to talk about the problems that I see in secret hearings because of my participation in them. I've observed a number of problems. Now, generally speaking, there are about 4 limitations that academics use in respect of criticizing secret hearings. The first is it's a secret hearing, and it violates the open court principle, which fosters transparency and accountability. In a secret hearing, you don't have that. Secondly, the secret hearing lacks the person who's directly affected, and indeed the person who has most of the information in respect of the issues before the court, which is obviously a problem in terms of fact-finding. The third point is that in a secret hearing, and the courts are particularly reliant on government officials to persuade them that the matter has to be heard in secret, and also to provide the evidence, the secret evidence, in a fair and comprehensive way. And there have been problems with that, some of which I will discuss. And the final criticism is the dynamic of secret or closed proceedings, as they are called, may condition judges to unduly favor the interests of secrecy and security. So those are generally the criticisms that we normally hear about secret hearings. Now let me come to the present regime under the new IRPA. As you know, in about 2007, in the Sharkawi case, the Supreme Court of Canada ruled the previous legislative regime to be unconstitutional. That was a situation in which Csis would go into court by itself before a federal court judge and ask the judge, in effect, to uphold the certificate. They batted 1,000. They never lost a case. I wonder why. In any event, the Supreme Court thought that that was unfair. And as a result of that, Parliament responded with a new regime in which they created the position of the special advocate. And the special advocate is an experienced security-cleared lawyer who was appointed by the federal judge to represent the interests of the individual or the named person in the secret proceedings. Now, there were a number of problems with it, but in terms of the relationship, there is no solicitor-client relationship between the special advocate and the named person. However, any communications between the special advocate and the named persons are protected by that privilege. One of the problems, which I will discuss later, is that the special advocate cannot communicate with the named person after he or she has seen the secret or the closed evidence. And that can only be done with the authorization of the judge. Now, the two key roles of the special advocate in the secret hearing, really, first of all, and in my view, the most important role, and that is to challenge the assertions of national security confidentiality of the government. In my view, the primary role of the special advocate is to get as much information as possible out to the named person and the public. The named person, once again, is the person most directly affected and the person who knows the most about the case. However, the second aspect, or the second role, is with respect to the secret evidence that has to be heard inside or in secret. The role of the special advocate is to challenge that evidence by cross-examining the government witnesses, by challenging the relevance, reliability, and the sufficiency of the evidence. Now, even though the new system, the system with the special advocate, is fairer than the previous system, in my view, it is still not fair. Of course, in respect of these kinds of proceedings, we're concerned about Section 7 rights, Section 7 of the Charter rights. That is the right to know and meet the case and the right to have a decision based on all of the law and the facts. And the constitutionality of that new regime was reviewed by the Supreme Court of Canada in a decision which was released this past May in the Harkat case, in which I participated as a special advocate. Now, in that case, the Supreme Court said that there are two guiding principles under the new regime. The first is the judge is a gatekeeper to ensure that the process is fair. And most importantly, the judge has to ensure that the named person is reasonably informed of the case against him. The second guiding principle, the Supreme Court said, is that the special advocate is intended to be the wording was a substantial substitute for the named person in the secret hearings. Now, although the Supreme Court ruled that the regime was constitutional, contrary to the arguments that I made, it did lay down a number of guidelines, which I think are very, very important, because it was clear in reading the Harkat decision that the Supreme Court did not view this to be a perfect process and required a number of improvements. And in the time available, let me just talk about 4 issues that the Supreme Court talked about. The first deals with government assertions of national security confidentiality. In short, the Supreme Court said the government overclaims. In fact, the Supreme Court went on to say that a judge must be vigilant and skeptical of assertions of national security confidentiality by the ministers. Went on to say that governments have a tendency to exaggerate their national security claims. And that, in my view, is a real admonition to government. This has gone on since the Arar inquiry, and indeed decades before that. Justice O'Connor made the same criticism in the Arar report. Second issue relates to communications between the special advocate and the named person. As I said, you need a judicial authorization to speak to the named person and his or her counsel. That is wrong. In the Arar inquiry, I had no restrictions in respect of speaking to Mr. Arar's counsel, to interveners after I had seen the secret evidence. The special advocates are experienced and competent counsel. You can trust them that they will not inadvertently disclose national security evidence when they're talking to me. And the thing that used to drive me crazy is that special advocates had these restrictions. And in the Harkat case, it was Paul Copeland and I, which had about 85 years of legal experience. And across the court, we had a one-year Csis lawyer who didn't have the same restrictions, because Copeland and Cavalluzzo may innocently but inadvertently disclose secret information. And it seems to me CERC Council is the same as the Arar Council, don't have those communication restrictions, and I think it's important that they should be removed. The third point is cross-examination by the special advocate in the secret hearings. And we argue that it's an unfair process, because most of the information that we hear in the secret hearings are either from Csis human sources or foreign agencies. In the information you get from foreign agencies, such as the CIA, they send information to Canadian authorities, and the information isn't even sourced. In other words, you don't even know where the CIA got the information. And there is no way that any lawyer can cross-examine that or test that kind of information. And the same is true of human sources, is that their information goes in and it can't effectively be challenged. The final point, I want to talk about Csis human sources, because there's a great deal of discussion going on these days because of the legislation that was introduced on Monday. Supreme Court of Canada in Harkat said that Csis human sources are not covered by the police informer privilege and are not protected by a class privilege. The bill introduced on Monday is going to create a class privilege for Csis human sources. What has happened is that Csis has persuaded the government, and indeed some of them go on to talk about judicial jihad, that these courts are crippling our operation, and we need this kind of protection, and the government has bought it. And the unfortunate thing is there are a number of misrepresentations and misunderstandings related to the Csis human source situation. First of all, a Csis human source is unlike a police informer, because the information that comes from the human source is relied upon by the judge in respect of legal liability, in respect of whether the certificate is reasonable. That's not the case of police informer information. Police informer information might be used to get a search warrant, but it doesn't go to the guilt of the individual. If they're going to testify about the guilt of the individual, they have to testify in open court and be cross-examined. The second misunderstanding is the way the government and Csis are presenting. It's like the courts are saying a human source is going to have to testify in the Air Canada Centre in front of thousands of people. Well, that's not the case. What the Supreme Court said in Harkat is that they might have to testify in a secret hearing. What that means is they would have to testify before a security-cleared judge and a security-cleared special advocate. 2 or 3 people. That's what we're talking about. The third point, which is misunderstood, is that the Supreme Court's decision in Harkat was very protective of the interests of human sources. They didn't say, well, the special advocate will immediately, just like this, get the opportunity to examine the human source. They said in most instances, the disclosure of the human source's identity will be injurious to national security, and as a result of that, their identity won't be disclosed. Or in terms of examinations, the same is true there. And they said that it would only be in the rarest of cases that a human source would be called to testify. The irony of all of this is that it was in the Harkat case that we discovered that Csis made misrepresentations to the court. We discovered in the closed hearings that Csis misrepresented the polygraph test of one of the sources. They said the polygraph test showed that the source was truthful. After examination by the judge and the special advocates, we found that he was found to be untruthful. Now, there is a situation where you're totally reliant upon government officials to be honest in the presentation of their evidence. They weren't. And that is a very, very good example of why we need the protection that the Supreme Court talked about in respect of access to human sources in appropriate circumstances. They will be exceptional circumstances, but indeed, you should have that opportunity. For example, when you catch the government lying. Governments have lied in the past. They may in the future. Now, in closing, I want to make just a couple of recommendations in respect of secret hearing. First of all, there's got to be an effective penalty on governments for overclaiming national security confidentiality. They have been admonished year in and year out. Yet in May of 2014, we have the Supreme Court of Canada saying the same thing. Governments overclaim. Governments exaggerate. And when you're involved in these hearings, you usually see what they want to hide. It's usually situations that embarrass the government. It's not usually national security problems. It's embarrassing situations politically. And so that there's got to be an effective check. To this point in time, we haven't found it. Second point, a recommendation that I would make, is that we should eliminate the communication restrictions that I talked about. It was successful in Arar, it's successful with Cert Council. You don't need to impose these kinds of restrictions on experienced, security-cleared lawyers. They have professional and ethical obligations, and that is a sufficient check. And the final recommendation, only said there would be two, but the third one would be the source situation. We should do everything in our power to avoid what was introduced on Monday. Human sources and Csis don't deserve a class privilege. The past demonstrates that beyond doubt. Thank you.
Thank you very much, Paul, and it's over to you, Marlys.
Well, I want to say I came with what I thought was, 10 minutes of remarks, and as I've sat and listened today, I have other things I want to talk about. Let me start, and I wish Justice O'Connor were in the audience, but I think he is not. Anyway, I want to follow up on this suggestion that maybe, inquiries sit around, all they do is gather dust, no one really integrates or responds to the recommendation of the Commissioner. Well, I want to ask you to put on your suspicious hat for a moment. I was Commission Counsel in the Blood Inquiry and worked with Horace Creever. We spent the better part of 4.5 years. Justice Creever made a huge number of recommendations, which included removing the blood program from the Red Cross, as well as a whole other set of recommendations. That happened. The recommendations came out, and the Canadian Blood Services was created within months. I appeared for Donald Marshall Jr. at the Marshall Inquiry. That inquiry led to multiple recommendations about how to avoid bad policing, how to avoid errors in the administration of justice, to ensure that people were not wrongfully convicted. It was our first such inquiry. It was not long before the most important decision the Supreme Court of Canada has made in the field of disclosure, it's a case called Stinchcombe, was released by that court, and holus bolus, they took the recommendations of the Marshall Inquiry around disclosure and inserted them in the judgment in Stinchcombe. That is why defense counsel today are entitled to have provided by Crown Counsel anything that is not clearly irrelevant. It comes to us. That's also true of the recommendations in the Sofino inquiry. It's also true from the Gouge inquiry. They have informed and educated the community of scientists, the community of judges who deal with forensic science, and on and on. So, with your suspicious hat on, ask yourself this question. While inquiries, expensive though they are, have proved to be so important in the administration of justice, in policing, in health, we have the Arar inquiry. We have 2 other inquiries. And I'm going to say, on the fundamental issues of oversight and change, nothing has happened. And with my suspicious hat on, I'm assuming that there is massive institutional resistance that prevents what I think are some of the best recommendations from being adopted, and which avoids oversight. From the perspective of being a lawyer, sitting in here today, this is what I've heard. I've heard the service lies. I've heard the RCMP lies. I hear that they have every interest in misleading the community to deflect any attention from their own wrongdoing. I have heard that both agencies are involved in and connected with huge human rights abuses that have taken place in foreign states. Well, if I were looking at this objectively, I would, if I could just put my social science hat on for a moment, I would say what is utterly and absolutely foundational that we need to come out of this meeting discussion today is that there must be a mechanism to review why we haven't gone anywhere. Whether that means going to members of parliament, whether that means kicking up a fuss with the next group who are running for public office. You know, I've read and reread Justice O'Connor's recommendation for integrated oversight. So we've heard a little bit about some oversight, but we have no meaningful oversight unless we adopt recommendations like those that he put forward or similar to them. And quite frankly, I don't know how to recommend that we take on institutional resistance, subterfuge, and things like that, except to be vigilant and suspicious of, and I mean profoundly suspicious, of claims that are being made today. When I, for example, hear about the need for more information sharing, I ask myself this question: what does that really mean? And will anyone really explain it to the public? Because we know that when Canada shares information, sometimes it can be incorrect. We also know that when foreign states share information, particularly if they have a bad human rights record, the information can come from human rights abuses and torture. The information can be dead wrong. Who in this room wouldn't sign a confession with 40 hours of beating? None of us. Bring in the piece of paper and I'll sign on the dotted line. There may be someone who's prepared to die, but most of us would seek to find some way to mitigate. So quite frankly, sharing of information terrifies me, because here's my vision of what's going to happen. We open up sharing, and either the police get the power to do a peace bond, but I can't believe that's going to happen. They can lay some process that will go before a justice of the peace, and the justice of the peace may be able to do it. So people like yours truly will walk into the courtroom, and the person will be detained, and the first thing you will hear, you'll say, "Give me the evidence." And you'll be told, "I'm sorry about that, but you're not allowed to see all the evidence. Here's his driver's license, but the rest of the evidence comes from intelligence." you can't see it, and you can't test it. And then I will move to say to Paul, Paul, will you be my special advocate in this, this peace bond process? And the JP won't know what we're talking about. And then, of course, an objection will be taken, and we will find ourselves in federal court. Now, so I want to just ask this question, and I'm probably talking too much, more than I thought. If I asked myself what's changed, in 1981, or maybe 82, this city saw an act which was what they described as one of the first terrorist acts to take place. Kenny Gungor was the commercial attaché of the Turkish embassy. He was shot and very badly wounded. 3 men were charged with conspiracy and attempted murder and stood trial. My first interaction with intelligence was to walk into that case with my 2 colleagues, or actually there were 2 of us for each of the accused, and begin to piece together the evidentiary record and realize there was intelligence. And we wanted it. Because if the police theory was they were conspiring and talking to one another to arrange it, we believed actually one of the witnesses was the shooter. So we set out to try and get the intelligence. We asked the questions at the preliminary inquiry, and out of nowhere at the back of the courtroom, a gentleman rose wearing a fedora and said, "I object." None of us had ever seen anything like this. Our first response was, "Shh, you don't do that in a courtroom." He was a senior official of the service, because this is now a little past 1984. Then we were off to federal court. We made our pitch to Justice Addy, who said, "I don't even have to look at the material. Don't have to look at it, because primarily this will be used by you to challenge the credibility of the 2 witnesses against you. And it will not give you evidence that is really innocence at stake evidence. It will itself be dispositive. So go away." So we waited till the trial. We get ready for the trial. We do exactly the same thing. Justice Addy graciously leaned down to me and said, "Oh, Miss Edward, you try so hard." Needless to say, the result was the same. We then were before a Superior Court judge who was anguished by the failure of the federal court to even look at it. But given the regime in place at that time, the only question he could, in fact, deal with was the breach of our access so severe, should he stay the proceedings? And because we didn't ever know what it was we didn't have, we couldn't reach that threshold. The accused were convicted. I work with Mr. Cavalluzzo, and I work in the special, with him as a special advocate in the national security context and the certificate context. I made a vow to myself many years ago I would only ever be public counsel, because I did not ever want to be in a position that I could not share everything I needed to share with my client. I did that with Maher Arar, I do it with Mr. Jabala, but I can only say this. I have done many serious trials, and to participate in this process is to feel that you have a blindfold on at all times. I do want to say one other thing. This issue isn't over. Currently knocking at the door of the Supreme Court is the case of my client Hassan Diab. At issue in the Diab case is whether or not the minister can commit him to stand trial in France in circumstances where the trial record in France will include bald, unsourced, uncircumstanced intelligence, where you read a line and it doesn't really say anything, and then you're looking at the record of the case, and then it says, "Oh, you know, we heard from a reliable source that he's guilty." And the issue is, can you send someone, even to a country like France, when that's going to be the evidence? And more importantly, no one gets to challenge it. Not only will Hassan Diab not be able to challenge it, the trial judges will not be able to go behind those assertions. And of course, you know, that's just part of the same horrific discussion. And at the end of the day, not only do we need a mechanism where we supervise, but we need a mechanism to ensure we do not sacrifice the administration of criminal justice. Thank you.
Thank you so much, Marlys, and it's over to you now, Barb.
Great. I'm going to cover sort of 3 areas and then add a 4th at the end that's not really related, but I want to say something about it. Who's targeted today, sort of taking stock of the last 10 years, who are the targets of national security, whether the process has improved to ensure that people who are the targets have a fair process. And the 3rd is really the impact on those people. I also want to say something about articles, news articles and press, because that we see Canadian news articles all the time in our hearings, and I have real problems with it. But just with respect to the targeting, I should explain first, I was tangentially involved, or late in the day involved, in the Arar Commission. So my clients wasn't Mr. Arar, it was the other men, Mr. Al-Mahdi, and to a certain extent Mr. Nuruddin, who were tangentially affected by that commission. With the Yakabuchi Commission, I wasn't involved at all because it was a secret hearing, and every once in a while we would show up and make public arguments, and that was the extent of our involvement. I acted for Mr. Al-Mahdi in that process, and I can tell you, if secrecy is bad, it re-victimizes the people by putting them through a process where they have no idea what's going on. They have to completely trust strangers to do the right thing, so that at the end of the day you may get a report that's good, as they did with the Yakabuchi Commission, but at what cost? I mean, it's really not fair to people to do that. Part of reparation has got to be transparency, and if one thing we learned from the Yakabuchi Commission, it's that transparency is super important for people who are victims. But anyways, that's an aside. But most of my cases, I act for Mr. Jabal, and I've acted for some of the people who are subject to the security certificates. Those are like 5 people in total. There have been a couple more over the years, I think 29 since it started in 1992. But I have an office full of alleged terrorists. They are people who are under the radar, they have no profile, and they are not terrorists. They are no different than us in this room, most of them. And that's the first point that I want to make. In the last 10 years, the government has not narrowed who is a terrorist. They've not learned from the false targeting of Mr. Al-Malki and Mr. Al-Mahdi and Mr. Arar. Instead, they have broadened their targeting so that you get cases, and the classic case, which I always talk about, is this poor woman who's like, I think she's now in her 80s. Her husband was a member of parliament in Sri Lanka for a Democratic Party. That party, a Tamil party, tried to speak to end the war in Sri Lanka for the LTTE. They tried to speak for the LTTE, a terrorist organization, in order to end the war because the LTTE was banned. Her husband was assassinated. She comes to Canada to join her daughters. She's a terrorist because her husband was a terrorist, because his party tried to end the war speaking for the LTTE because they couldn't speak themselves. They were really speaking for Tamils, but the LTTE wasn't speaking, so they were seen as the proxy in place of the LTTE. And her crime, she cooked dinner for her husband, she raised their kids, and she typed his notes. And worse, she knew what he believed in. She understood it, therefore she's a terrorist. I mean, that's how broad the laws are. So when the Immigration Act allows for deportation of members of terrorist organizations, it covers people like her. It hasn't narrowed, and if anything, she didn't even get leave in the federal court. If anything, it has been broadened by the courts. The courts who are supposed to scrutinize and ensure that unfair decisions are not made are the ones responsible for the broadening. I think it was Justice Rothstein first in the Iqbal Singh case said, membership has to be read broadly and unrestrictedly. How can you have a definition that's unrestricted? But we have had an unrestricted definition since 1992. I think the Iqbal Singh case was in the early 1990s. Justice Rothstein, his framing of the definition as broad and unrestricted has been picked up by most judges in the court, and it's only in the last couple of years that some judges have questioned whether you can have an unrestricted definition and have sort of started to put some limits on it. So we have that, the broadening of who's the target. We are going to have a further broadening of who's the target by the changes to the Citizenship Act. That the government will be able, not the government, the minister, by sending a letter, will be able to take citizenship away from kids born in Canada, young people born in Canada, or naturalized, for criminal activity. So if they have a loyalty conviction, where they got a life sentence, or a criminal conviction which was motivated by religion or politics, for which they got a 5-year sentence, economic or personal harm, violence, that's what they call terrorism, and there will be debates about what's terrorism. They can be denied, or they can have their citizenship taken away from them. It covers citizens who may have access to another citizenship. They don't have to have it. They're born in Canada, second generation, even in some cases, but as long as they have the government believes they have a potential to get citizenship in another country, they will become stateless because they'll take their citizenship away. It is retrospective for people convicted outside of Canada, so guess who's the first person going to be caught by it? Omar Khadr, because he got 8 years by a US military tribunal. That will bring him within the class of Canadian-born Canadians who can lose their citizenship. The future, because hopefully at some point I'll retire, the future for young lawyers will be fighting this kind of legislation. When you think of it, citizenship is meaningless if they can just redefine it by statute. What does Section 3 or Section 6 of the Charter mean? It means nothing if they just redefine it. And you can be sure once they start one class of criminality, they will expand it so that any criminal can't be a citizen in Canada any longer. So in terms of the targeting, it's not narrowed. There's no principal restrictions. There's no court oversight, or very little court oversight. I think there's some developing more recently. And it's expanding to cover citizens, not just non-citizens. That whole wedge issue of us and them includes Canadians who aren't really Canadians because their parents or grandparents came from another country. It's not all Canadians whose grandparents or parents came from another country, just them, those ones that we don't like. With respect to the process, there have been improvements as a result of mostly of court cases, the Sharkawi case, and the concerns that you have to see the Akabuchi Commission result and the Arar Commission as having an impact on the courts taking the concerns seriously about lack of fair process, and obviously secret evidence is important. So in the procedures before the federal court, the judges have excluded evidence where the original evidence was destroyed, for example. They haven't, it's been very uneven, so if you get evidence tainted by torture, they've mostly, as far as we can tell, of what's public, and we don't know what's not public, of the evidence that's been put in against people from particular countries, if you could show specifically that there was torture going on, that evidence wouldn't be looked at by the court. But it looks from the decisions like the routine practices of torture is not enough to exclude evidence. So they'll still look at evidence from countries like Egypt and Syria and places like that, unless you can show a link, unless you can show a direct link to torture. Now, my friends may correct me on that. Maybe I'm overreading it, but that's how I read the decisions. It's very problematic, and it does leave the door open for, in the future, for sharing tainted evidence, I think, as long as it's still got some justification on the books. The federal court does use the special advocate system properly, I think, well. The difference between the court hearings before the Supreme Court said you had to have some kind of special advocate, and now it's not perfect, but it's certainly a lot better. It's like it was more before the Security Intelligence Review Committee, but with the restriction on not being able to talk to the lawyer, the special advocate, without the judge's permission. But you know, the federal court cases are 5. There's what, 1 left, just the Jabala case that we're finishing up. There's hundreds and hundreds, if not thousands, that are going before Immigration Division members every day on alleged terrorist grounds. And you know how they get disclosure? The government puts in an affidavit, they block out the name and evidence they don't want you to know about. We say we want a special advocate, and they say, well, we're not relying on the secret evidence. That's it. You don't get a special advocate. You never get full disclosure. When you argue that we have a case where they put in a news article which cites a judge's decision, 280 pages, they're using the news article, not the decision. We want the decision. Well, if you have a problem with the decision, you get the 280-page decision and you show us where it's wrong. So instead of disclosing, it's up to the person to challenge it by bringing in other evidence. Special advocates are few and far between. I've only got a couple of minutes left. So that kind of procedure, the one that everyone else is going through, that most people are going through, appears to be independent and impartial. It's not. It's a rubber stamp for the government. And the degree of fairness is minimal. The federal court has distinguished it by saying it's not the same as the security certificates, even though they're all going to end up deported, on the same kinds of grounds, exactly the same grounds. They don't have the same level of fairness. The last part, because I have to keep moving on, I only have a few minutes, is the impact. Mr. Al-Malki and Mr. Al-Mahdi and Mr. Arar, Mr. Nurdin, they were all tortured in other countries. We don't torture people, but the Omre case went up to the Supreme Court of Canada, 5 years in solitary confinement. We had to go to court to get him shoes to wear in solitary confinement. That was found not to be cruel, because now we're going to have hearings every 6 months to decide whether or not he can be released. We sanitize the mistreatment of people in Canada, I think. And I think over 10 years we haven't learned. If anything, we think we're a nice country. So if we keep someone in solitary for 5 years, that's not cruel. It is in Syria, but it's not in Canada because it's us doing it. You know, it's the banality of evil. That's what it is. And that hasn't improved. I mean, every day through these kinds of unfair procedures, people, individuals, and their families are being harmed by Canadian officials in very real ways. People have come out of the security certificate process with post-traumatic stress from the process in Canada, not from anywhere else. That's wrong. That hasn't changed. That's gotten worse, especially worse because detentions are now more common. And then the last point, and I will be really quick, Alex. The last point is the press. There was this discussion about the news articles. What happens when you report on proceedings in the cases I've been involved in is they become part of our record. The government brings them to court the next day and makes them part of the record and uses the report about what happened in the hearing as part of the evidence against the person. And they're allowed to do it. So, you know, I mean, we've objected and objected and objected. I just objected last week on that. Another case, it's a third article they put in that was written by the National Post that's now become part of the evidence against our client. So it's an ongoing problem, and there isn't any rules of evidence before these tribunals. They take things like newspaper articles. They believe them whether or not they're reliable or credible, and there's no oversight on that. So the end result, I would say, is on 3 levels. Secrecy is wrong. It hurts people, and it should go. There has to be meaningful, fair procedures at every level, not just the federal court. And there has to be oversight to make sure that these things improve rather than get worse.
Thanks so much, Barb. I know any of you could easily fill this entire panel. You've got so much experience and so much to share. So we're going to move on now to our 4th presentation, Phil Tunley.
Thank you very much, Alex. My firm acts as the civil counsel for Messrs. Al-Malki, Al-Mahdi, and Nurdin in their claims against the Government of Canada for compensation, for damages. And to answer Ian Scott's question earlier, we will be paid, if at all, on a contingency basis when we're successful in that mandate. So some people ask, what does that have to do with human rights? And I want to answer that question by pointing to the United Nations Convention Against Torture. Article 14.2 states, each state party, that's Canada, shall ensure in its legal system that the victim of an act of torture obtains redress and has an enforceable right to fair and adequate compensation. That is an international human right for victims of torture, and that is what we are dealing with in the civil actions. Justice O'Connor, in his inquiry in 2006, recommended compensation and an apology for Mr. Arar. Justice Iacobucci, in his report in 2008, in his terms of reference, he was denied the ability to deal with this issue. He was precluded, but he made the same findings of complicity, in effect, in torture by the Canadian government. So when Parliament, through its Standing Committee of Public Safety in June 2009, reviewed Commissioner Iacobucci's recommendations, it recommended compensation and an apology for Messrs. Al-Malki et al. And that recommendation by the committee was adopted by the full House by resolution on December 3rd, I believe, 2009. Now, it doesn't stop there. The United Nations Committee Against Torture, an expert body, recently in June 2012, wrote a report on Canada's compliance, actually non-compliance, with the UN Convention to which it's a signatory. It expressed serious concerns about Canada's failure to provide an apology and compensation to Messrs. Al-Malki et al. And it found specifically, based on the Iacobucci report and its findings, that Canadian officials were complicit in their torture. So I start with the proposition that every day these three gentlemen are not compensated, this country is in continuing violation of its international human rights obligations under the UN Charter. Now, when I take that position, people say, well, were they really tortured? And there again, it's clear. Justice O'Connor, in his inquiry process, appointed a special expert fact finder who interviewed not just Mr. Arar, but Messrs. Al-Malki, El-Mahdi, and Nuruddin. He found as a fact that their accounts of torture in Syria, specifically, were consistent. They were supported by international monitor reporting by agencies such as Amnesty International and others, and they were credible in terms of the individuals making those allegations. When Justice Iacobucci held his inquiry, he retained independent medical experts. Messrs. Al-Malki et al. All submitted to medical examination by a clinical psychiatrist, a forensic psychiatrist, and a clinical psychologist. There were tests. Their reports concluded that all of the claims of torture were credible and medically supported. Now, as counsel in the audience know, these are not my experts. I didn't seek them out, look for a good opinion. These are independent, and they all allowed me in the civil actions to use their reports and potentially call their evidence. So there is no doubt that I will be able to prove that the torture occurred. There's just no doubt about it. This is formally denied by the Attorney General of Canada. And again, the United Nations Commission Against Torture, an independent body, reviewed all of those findings and agreed. So what often puzzles me is how this plays internationally and here at home. I read with interest a report in 2013 by the Open Society's Justice Initiative called Globalizing Torture. What was striking about that is it finds Canada prominent among 54 countries who knowingly participated in the US programs involving secret detention and extraordinary rendition. So we're in the company of countries such as Australia, Austria, Belgium, Denmark, Finland, Germany, Greece, Ireland, Spain, Sweden, and the UK in that regard. But what it didn't note, and what is important, is Canada is one of a much smaller group of countries in the world than 54 who actively participated in the rendition and torture of their own citizens. That's never been reported. It's never been commented upon. Instead, in a Globe and Mail editorial in February of 2013, what was picked up on from this report was the one finding that was good. Canada is the only country to have apologized and compensated one of its victims. As we know, one of four. The Globe and Mail talks about the Arar inquiry as Canada's, quote, national soul searching. and commends us for being right to beat ourselves up, and even tries to shame other countries by saying, well, we're the only country that did that. Gee, aren't we great? The fact of the matter is that until all of the victims of torture in Canada are compensated, we are in breach, more serious breach, I would argue, than any other country, of our international human rights obligations. Now, the other thing I want to talk about is the United Nations Charter right to a prompt judicial process. That's found in Article 13 of the United Nations Convention, which says each state party, that's you, Canada, shall ensure that any individual who alleges he has been subjected to torture has the right to complain to and have his case promptly and impartially examined by its competent authorities. So let's look at the record in Canada on that international human right. So Mr. Nuruddin's action was commenced in 2004, within months of his release from custody in Syria. The others were released very shortly after, and their actions had been commenced by 2006. Production of documents, they produced all their documents in the actions by 2009, very shortly after the Yakabuchi Commission reported. The Attorney General didn't even attempt to and didn't manage to complete its first round of production until 2012. That's more than 10 years after the events concerned, and it is more than 6 to 8 years after the actions were commenced. That's just producing the first round, 12,000 documents. They'd been through 2 inquiries. You would have thought they had listed out their documents that were relevant during that process, but no, it took that time to get them together. Of that 12,000 documents, fully 5,500 have what's called national security redactions, big black parts where the government doesn't want us to know what they say. I can tell you there are many documents, hundreds and more pages long, that are entirely black. I know nothing about the author, I know nothing about the subject, I have no date, I might know the date. It'll be called report, and it'll be black from start to finish. It's unprecedented. Never before has this occurred with this amount of material to be reviewed. Those 5,500 documents are currently before the Federal Court of Canada. In a daunting process, I want to salute 2 amici of the court have been appointed to help with a review. This is a virtually impossible task. They have been working, I would say, virtually nonstop since 2009 to undertake it. In the order appointing them, there is a provision which says that in their pre-hearing review, the amici are to act as if they were counsel for Messrs. Al-Malki et al., which only makes sense. There's no point in having a review, and certainly I'm not going to accept the result as binding unless they act in that capacity. Well, the government fought that provision. They didn't want anyone in this review process acting on behalf of our clients. There's another provision in there which says these amici are to identify material that, although it can't be provided to me and will never be shown to Mr. Al-Malki, can nevertheless be shown to the trial judge, who may sit on a motion to dismiss this action, dismiss the defense of the government for failure to produce relevant documents. The Government of Canada opposed that provision as well. We have finally succeeded in getting a communication order. Paul referred to this. It's absolutely essential. On procedural issues only, we now have an unlimited right to speak to the amici and for them to speak back to us on procedural issues. Well, the government opposed that. Right, we only obtained it last month. So, I want to finish with, while we've been doing the review in federal court, which is a very time-consuming process, and I just want to, again, commend the amici. They do a phenomenal job. It is hard, you can imagine, going through 5,500 documents and arguing about whether information is protected or not protected, and whether it's relatively important or not important in the litigation. While that process has been going on, even the 12,000 documents we got from the government were not complete. We had to bring a motion in the Superior Court of Justice. So we're dealing with two courts, each of which wears a different hat on parts of the production of document issues. We had finally had success on a motion that was heard and determined in July of last year, and as a result of that have emerged with a discovery plan. I'd like to just go through with you some of the things we were able to achieve. And at this point, our case management justice, Justice Paul Perel, is quite concerned about how long this is taking and the failure of the government to produce. So what he ordered, among other things, are, first of all, he ordered that the Government of Canada and we prepare witness statements of our expected trial testimony of the witnesses in the case to assist in what is otherwise, as was mentioned earlier, pretty much a blindfold discovery process. So I now have 68 pages of 30-plus witnesses that the Government of Canada intends to call to support their defense of the actions. He ordered that you've heard that these two inquiries, one entirely and one substantially, occurred in private. He ordered that the Government of Canada produce and redact and produce to me the in-camera transcripts that are relevant to our actions. And then those will have to be put into the federal court review process after the 5,500. There are 400 volumes of transcripts, and I'm now reviewing the edited to the extent I'm allowed to. He ordered that we engage in a process, and we have done, of preparing an agreed statement of facts about the very complicated institutional background to all this, to try and save the need for a trial judge to duplicate all the findings of the various committees. So we've been doing that. He ordered the production of monitor logs and audio tapes for RCMP and Csis intercepts. And he ordered, what the government has a habit of doing is, instead of where they have 50 documents in a file, they won't break them all out and describe them all. They'll give you one, and then all the others will be wrapped up behind what's called a composite document. So we got an order that requires the government to go through and break out all of those composite document components and describe them separately. Most important, and to conclude, Justice Perel ordered that there be a trial. He, of his own motion, set this action down for trial. And so I now know that I'm going to have a trial of these actions in September 2016. That's 2 years from now. And the very good news is that that's a trial in Superior Court of Justice, and it's going to be a public trial. Anything that is not produced to me will not be heard. So if the government wants to hide anything to the extent that they don't want to show it to me, they can't rely on it. And the last thing the judge ordered was $125,000 plus in costs, which is a pretty nice way to end that particular outing. The Government of Canada's efforts to drag out and stonewall and prevent this matter from going forward have been numerous and endless. We've committed our share of mistakes, I am sure, in terms of things that we tried to do that ended up not being successful, so I'll share some blame. But now we have a trial date, and I'm very pleased that Abdullah, Ahmed, and Muyad will have their day in court. This is the only day, this is the only process that they control and that they have to bring these matters to conclusion. Thanks.
Wow, well, I'm sure everyone's reaching for their 2016 agendas. There would be many people who would want to be in the front row of that. But thank you to all of you. I regret to tell the rest of you that we are running tight to time, so we actually don't have an opportunity for question and answer at this point. But I think our panelists are here for the rest of the afternoon. We have a short break right now before we go to the next panel. So certainly if you did have something on your mind that you wanted to react to or ask about, you've had a tour through a whole variety of different legal settings and lots of challenging issues and important recommendations that have come out of that. We will resume at 3:30, so do grab a coffee and come back for the next panel. Thank you again.